In the late 2000s, Amazon had a problem that most companies would love to have. It was winning too easily. Through its Kindle store, Amazon dominated the ebook market. It sold best-selling digital books for $9.99, sometimes even losing money on each sale. Consumers love it, readers love it, but publishers hated it. Because if readers got used to paying $10 for a book, how could publishers ever convince them to pay $20? What happened next wasn't just a business strategy. It became one of the most important antitrust cases in modern digital markets. A case that asked whether a company trying to reshape her market had crossed the line into illegal price fixing. At the time, Amazon controlled nearly 90% of the ebook market. Its strategy was simple: sell books cheaply to build the Kindle ecosystem. The cheaper books were, the more people bought Kindle devices. But publishers saw a long-term danger. If Amazon controlled both the device and the price, it could eventually control the entire industry. Several large publishers, including Hachette, HarperCollins, and Penguin, began searching for a way to push prices back up. But no single publisher could confront Amazon alone. If one publisher raised prices while the other stayed at $9.99, readers would simply buy different books. What they needed was leverage, and that leverage arrived in 2010. When Apple prepared to launch the iPad, it needed something to compete with the Kindle. The device was powerful, sleek, and expensive, but without books, it couldn't challenge Amazon's ecosystem. Steve Jobs and Apple executives began talking with publishers. What they proposed sounded appealing. Instead of Amazon setting book prices, publishers themselves would set the price. Apple would simply take a 30% commission on each sale. This model is called the agency model. Under it, publishers regain control over pricing. But there was a catch. Apple's contracts contain a most favored nation clause, often called an MFN. This clause guaranteed that Apple would never sell books for more than Amazon, which means something important. If Amazon kept selling books for $9.99, publishers would have to lower Apple's prices to match. The only way the new system worked was if all publishers forced Amazon to raise prices too. And that is exactly what happened. Within months, several major publishers moved their titles to the new pricing system. Suddenly, the familiar $9.99 ebooks disappeared. Best-selling titles now cost $12.99 or $14.99. From the publisher's perspective, this restored balance. From the government's perspective, something else had happened. Competitors had effectively coordinated to raise prices across the market. The Department of Justice began investigating. What they wanted to know was simple: had Apple merely entered the market, or had it helped orchestrate a price-fixing conspiracy? In 2012, the U.S. Department of Justice filed an antitrust lawsuit against Apple and 5 major publishers. The government argued that Apple had acted as the central organizer of a coordinated effort to raise ebook prices. The evidence wasn't a single secret agreement. Instead, it was a pattern. Executives from competing publishers had frequent communication. Contracts with Apple were signed in close succession, and prices across the market rose almost simultaneously. The DOJ argued that Apple had knowingly helped competitors align their pricing strategies, behavior that falls directly under antitrust law's prohibition on price fixing. Apple saw the situation very differently. The company argued that it had actually increased competition. Before Apple entered, Amazon controlled the market and dictated prices. By introducing the agency model, Apple said it gave publishers a way to resist Amazon's dominance. In Apple's view, it wasn't coordinating a conspiracy. It was creating a second platform, one that finally challenged Amazon's control. From Apple's perspective, the lawsuit punished a company for trying to compete. In 2013, U.S. District Judge Dennis Cote ruled against Apple. The court concluded that Apple had played a central role in coordinating publishers to raise ebook prices. Even though Apple had entered a market dominated by Amazon, the method it used involved aligning competitors' pricing decisions. Under antitrust law, competitors cannot coordinate prices, even if they believe they are correcting another company's power. The court ordered Apple to modify its agreements and allow greater oversight of its ebook business. The Apple eBooks case highlights a complicated truth about markets. Apple may have wanted to challenge Amazon's dominance. Publishers may have wanted to regain control of their industry. But the law drew a line. Competition must happen through independent decisions, not coordinated price increases. In digital markets especially, the difference between strategy and collusion can be surprisingly thin. The courtroom becomes the place where economics and law collide.